Come to order. This is a public workshop. It is 5 p.m. This workshop will provide an update on the quantification settlement agreement and its coordinated cases. Mr. Brady?
Mr. President, before we start, we all like to wish Director Hanks a happy birthday today.
Oh.
He's 21 years old.
Happy birthday.
Happy birthday, Jim.
It's my anniversary.
And your birthday.
It's 24th anniversary of my 40th birthday.
Young man.
Thank
Excuse me, Director, would you like to comment more?
No, I...
Oh, okay. All right. Mr. President, members, and members of the public, if you're here tonight, you know about the Sacramento Superior Court judge's ruling that 12 of the 30-plus water sharing agreements that make up the quantification settlement agreement were ruled invalid. And that's a ruling, of course, that IID intends to appeal and seek a stay of the order to keep the QSA and related water transfers in force while it attempts to remedy what we consider a narrow basis for the decision. That basis was and is the Salton Sea, along with the financial responsibility for mitigating the effects of the transfer on this body of water, a very troubled body of water. What form that remedy might take is unknown at this point, but it'll be the district's goal to obtain cost allocation for transfer impacts on the sea that it thought it had 6 years ago. In other words, we want what IID thought it bargained for when the deal was signed back in '03. It's not my duty here to give a history lesson on the chain of events leading up to the signatory to the QSA. We all know it's the nation's largest ag to urban water transfer. I wasn't GM at the time, and I think it'd be most productive to deal with the future, not the past. So I think it's important that we remember this agreement. It represents over 25 years of compromise and consensus building among the parties to the QSA and that of IID among the community of water contractors on the Colorado system. For tonight's workshop, following the staff presentation and during the comment period, which we hope to have a free exchange of ideas, hopefully not a showdown at the OK Corral type, but what we have for your presentation, I don't know if many of you probably already have it, but over in the corner here is a copy of the presentation. And we're going to go through the staff presentation all at once, not take any questions, but if you have that, you can write notes, so you can ask questions later on. Also, I'll mention this a couple of times, but if you want to speak, we have a note card for you to fill out, and those will be over there. And so we'll have that opportunity. We want to talk about the resolution passed by the board on January 5th. There were three things that the board and staff is committed to. That is a transparent process. That's the reason for this workshop and other workshops as may be necessary, to provide a meaningful dialogue within the county, and we certainly have a great cross-section of the county here today, and then, of course, a preferred plan and continuing appropriation for the Salton Sea. Also, go to the next slide.
What about questions and answers?
Oh, I'll get to that. I testified, as some may know, I testified before Congresswoman Napolitano's field hearing from the U.S. House of Representatives, in part on the QSA. Along with me was Mike Connor, Commissioner for the Bureau of Reclamation. His comment on the QSA, you can read it there. The federal government believes it has valid contracts under the QSA and intends to stand behind them. And that was reinforced. I was in D.C. this last week with Interior. That is their position. And then Lester Snow, who is the director of DWR for California, also the Secretary-elect of Resources for California. And his comment was whether or not through appeal or administrative remedy there will be a quantification settlement agreement, speaking for the state. So those two things. One thing I do want to mention, and I'll mention it after the staff presentation as well, is that tonight staff is going to give the board and the public our best information on the QSA for your consideration. Then there will be public comment. This is not meant to be a debate tonight. It's the opportunity for you as public to give the board information and opinions and solutions and whatever's on your mind. And then at the end of public comment, the board will have the opportunity to make comments as they see fit. But we're going to try because we have a lot of people here, and I'm sure there are a lot of people that want to talk. Again, we are going to go through this staff presentation, then we're going to go through the speaker cards, and then the board. Let me just say, our first presenter is going to be Tina Shields. She's going to address chronology of events and some of the protections that we as staff see that the district has as being signatory to the QSA agreements. IID biologist Bruce Wilcox will talk about habitat and air impacts, mitigation efforts, and then Jeff Garber, our general counsel, is going to talk about some of the legal aspects, and then we'll be done. So, Tina.
And we can talk about the fact that they can make questions, but we can respond in writing.
Oh, yeah. Thank you, general counsel. One more thing. We're not going to try and answer. Obviously, well, I think we're going to get a lot of questions from the public. You may have questions of the presentation. We're not going to try and answer all the questions, but we're transcribing all the questions. We're going to answer those in a very short order. Put those the answers to the questions out after this. So, I mean, I hope there's no expectation that there's that we're going to close the loop on every question tonight. But we do have a process to get those questions answered. Sorry, Tina.
Hi, I'm going to try to briefly summarize for you the chronology of events that led up to the QSA, as well as some of the primary protections that we have identified from that series of agreements. The QSA is a long process, and we have started our chronology here back in the early 80s with Decision 1600 and findings that the IID needed to improve its efficiencies. That led up to the IID Metropolitan Conservation Program, which funded a series of investments to improve IID's operational aspects and system conservation. In 1995, that led to an MOU between the San Diego County Water Authority and the IID to look into pursuing additional conservation mechanisms and funding arrangements to push those further forward. In the late 1990s, we saw a big push within California to hold California to within its 4.4 million acre-foot entitlement of Colorado River waters. The Colorado River Board and many of the water agencies pushed forth a California 4.4 plan, which sort of was the precursor to the QSA. The main impetus for that 4.4 plan was trying to get California down to its legal entitlement as the states of Arizona and Nevada more fully developed their water resource programs and minimize the unused entitlement that was going to be available in future years. Through that process, the key terms for the QSA were developed along with additional mechanisms to push the QSA agreements and different versions of the QSA before the final version the board ultimately adopted. Through that process, the IID was not successful in reaching an agreement that could satisfy their board, and by the end of the negotiations in 2002, a deal still had not been reached. We did see in 2002 a reduced water order issued to IID in December of 2003, That reduction was in the neighborhood of 300,000 acre feet, and the Bureau was trying to move that forward. The IID took them to court and received an injunction in March of 2003 that prevented the implementation of that and the limitation that they were attempting to oppose. But what the courts essentially said at that time is to the Bureau, you didn't conduct your 417 reasonable use process correctly. Go back and do it again. So we did see the Bureau move forward in those efforts. Catch up with my slide here. Through that process, there were additional negotiations with the QSA, and different iterations came forth that the board, again, failed to adopt. And then finally, towards the end of 2003, there was an agreement reached that resolved the remaining issues and allowed the board to adopt the QSA in its present format. Through that process, there was a validation filing in order to move those agreements forward, and that brings us essentially to where we are in 2009 with the most recent judge's determination. There's some primary protections that we have identified in the QSA, the first of which is the attempt to meet the 4.4 plan that was being pushed by the Colorado River regions and the other water users, trying to get California to live within its 4.4 entitlement and not use waters designated for other entities. Again, that also provided IID with a peace treaty. We've spent many years and many dollars fighting the different agencies and amongst ourselves to determine who had access to what water. The agriculture entitlement was not quantified. There weren't specific limits on the ag agencies. And in order to move any of these transfer agreements forward, you needed to have each agency have a strict limit that they had to live within. We also have to keep in mind that the QSA is part of a larger process and series of agreements. There's been some additional shortage sharing guidelines developed that use the QSA as a basis and a primary focus. There's been some coordinated operating criteria. So the other basin states and water users have moved forward using that QSA as a benchmark to build upon to try to increase the reliability of the water supply in the Colorado River region. Again, the cap of 3.1 million acre feet that IID agreed to live within, it's a number that is larger than our historic average, and also mechanisms were put in place with the adoption of that cap that allows IID some flexibility in its implementation. The primary component of that is the inadvertent overrun and payback policy that allows IID a 10% margin of error or cap push that we can use a little bit more in some years, provided we agree to pay back that water in future years. So there's not as much a concern that the gate would slide shut at a certain point in time and we wouldn't have water to finish out our crops. That leads us to the fact that the QSA provide a revenue stream. Those monies are designated to improve system and on-farm conservation practices, many projects of which, had we not had that funding opportunity, would have been added onto the rate over time and in the future. So it really is a rate stabilization mechanism when you look at it from a big picture, long-term scenario. Also built within that different permitting systems was the development of a habitat conservation plan and a natural community conservation plan, which really provides IID with a lot of environmental security and certainty in the future as additional issues are raised with regard to environmental concerns and habitat protections. A key component of this is one of the primary benefits to IID of the existing environmental permits and processes is the coverage from an environmental perspective of all of our operational and drainage activities, and that is being funded by the Joint Powers Authority, which is the consortium of water agencies. So it's a protection that IID is not obligated to pay for. Absent the QSA, those would be additional permits and authorities that we would have to go obtain on our own and fund as well. And finally, the last benefit identified for everyone's consideration is the species conservation, habitat, and air impact mitigation efforts that are already underway. And I think it's the intent that these mitigation obligations would serve as the bridge towards restoration or habitat beneficiary type of activities in the future. And with that, I'm going to let Bruce Wilcox speak.
Thank you, Tina. The last 2 points that Tina made, I think, are important concepts to understand that absent the QSA, IID's responsibility for federal and state wildlife permits does not go away, and some kind of permit process would have to go into effect. The deal that was cut so many years ago, 2003, is a much better deal than I think you could get now. The agencies have ratcheted up their level of compliance, and we'll talk about a few of the things we're doing now. And again, keep in mind that these really are buying us operation and maintenance flexibility. One of the mitigation programs that's underway right now is the Salton Sea mitigation water, and there's been some discussion about the sea receding and playa exposure. The QSA provides for mitigation water delivery to the sea until 2017. There's probably a lot of reasons the sea is receding. Some of the economic impact of reduced farming this year has reduced sea inflows. Water coming through the two rivers from Mexico has reduced. There has been a bit of a drought the last few years. All of these things are combining to reduce the sea elevation. The IID has met its mitigation requirement in delivering water to the sea. Another issue that comes out of this and is part of the coordination we've been doing with the state and the federal government and some of the other landowners is some of the habitat projects that are at least in the planning stages now that will do what Tina said a moment ago, bridge some of the gap between Salton Sea restoration, QSA mitigation, and just some kind of reclamation at the sea. The saline complex habitat is something that's in the NCCP. It's a requirement that so many acres of this habitat will be built. It's salty habitat for fish primarily, but one of the other things that it does is control playa exposure, and it's very important from our air quality mitigation, which we'll see in a minute. Species conservation habitat is the state's latest term for what they're planning to do. We've been in coordination with them. Some of the things we're trying to do is use land wisely that IID owns and other and other agencies own around here to locate some of that habitat. We'll talk in the next slide a little bit about some of the land use value that comes with that and how we can remain flexible with the agencies and still be able to do some of that mitigation. And then finally, a phytoremediation project. You'll remember that most all of the proposed restoration project at the sea requires some kind of water treatment. The phytoremediation project referring to there is a state project likely to be located on IID property. All of these things we're moving forward with under the QSA mitigation. Pardon me. One of the other mitigation requirements is the air quality mitigation requirement. As you heard a minute ago, some of the land use or some of the habitat restoration projects that we're proposing do some level of air quality mitigation by locating on playa, but also as part of that, under the four-step mitigation program in the EIR for the QSA, we have a monitoring system that is in the process of being installed. This is one of the stations at Sunny Bono. This week, they're undergoing training on how to operate these stations. All of the stations are up and running and collecting data. The idea is we will collect baseline and background data so we can better understand what areas of the playa are emitting dust so we can target our pilot projects and our other habitat. And it will give us an idea of how much dust exists there now and give us some kind of an idea of what we have to mitigate in the future. Also under the QSA mitigation, some pilot projects. These are anything from just flooding the playa all the way up through habitat air quality management, which is a kind of a combination of habitat and moat and row kind of approach to air quality mitigation. We also have some other potential projects under there. Salt crust. One of the things that we are planning to do after September 15th is on the New River. We will install culverts up and down the New River Delta to bleed water out into those exposed playas to try and keep them wet, to reduce air emissions, perhaps even increase habitat, but certainly reduce air emissions. Under land use, one of the things that I talked about a moment ago when we talked about some of this other habitat was some flexibility in land use. From a air emissions control point of view, it's important to be able to cover that land with something, but it doesn't have to be habitat. It doesn't have to be water. We could use geothermal. We could use reclaimed farmland. We've talked to some of the farmers, particularly over on the western side of the sea, about reclaiming some of that area. We've also talked at length with the state agencies and the federal agencies about some flexibility in the habitat that we build or they build in allowing a combination of land uses with geothermal and some of the habitat in those areas. All of these things are in the works. We are probably a couple of years away from any kind of habitat on the ground, but certainly the pilot projects and some of the other air quality stuff will occur relatively quickly. We've had a lot of cooperation from local landowners in working on this too. I know Al, for instance, has been involved with us on the river deltas. We appreciate that input. And hopefully as we move forward, these are some of the things that we can do that are relatively inexpensive and provide some mitigation to the air quality and the habitat. And then finally, just a quick update on the managed marsh. Phase 1 of the managed marsh is completed. Again, I have to say that we've got a tremendous amount of local input and help in creating this marsh, and we greatly appreciate that. It's about 360 acres. That shot is from, I think, mid-November of last year. Since then, we've got some vegetation growth in there. It got kind of cold, and some of the vegetation senesced, but we still have made progress. This is, as Tina mentioned earlier, this is direct mitigation for our O&M activities. It is funded through the JPA, the water, the ongoing maintenance and management and monitoring, all funded through the JPA. It's very likely that something like this and more of it would be required for O&M activities without a QSA. Species mitigation, the different wildlife species. Burrowing owls is a big concern in the valley, probably because the population is largest here as any place in the state. The burrowing owl is not listed right now, but we are actually headed for meetings this weekend in Livermore to talk about another move to try and list the burrowing owl. So again, we have the protection under the HCP and the NCCP for this burrowing owl right now. If it lists, that's going to be even more difficult from a mitigation point of view, absent these permits that we now have. We've also done a lot of habitat modeling and monitoring. We just finished a 3-year baseline survey of the entire service area, over 500 square miles, of about 86 covered species. We're at the point now where we're about ready to put that model together and do the statistical analysis so we can use that for future monitoring and future mitigation efforts. That's ongoing and should be finished in about 6 months. And then finally, pupfish measures, which really raise a lot of issues and concerns, especially at the Salton Sea, and reconnecting the drains and keeping them connected and cleaned. Again, we have that coverage right now. Pupfish are a protected species. We have some requirements to build a refugium, and we have some requirements to do very specific drain connection mechanisms that, again, are funded through 3 water agencies right now, and we would be required to do that and probably more without the JPA funding. That's pretty much the main mitigation issues that we've been undergoing. And Jeff, thank you.
Good evening. I've been asked to talk about 3 things. First of all, I've been asked to give an update on the status of the QSA coordinated cases up in Sacramento. I've been asked to talk about the price dispute settlement that was reached recently with San Diego with regard to the water transfer, and also to touch upon this issue about a second opinion that the board has directed staff to move forward on. I'm going to talk about the QSA cases a little bit on a real basic level. The cases up in Sacramento, I see Mr. Sutherland, Ms. Wang Fu, some of the other attorneys in the audience. I'm not going to tell you anything that you don't know. I'm not going to argue, but I get a lot of questions from a lot of people that really don't know what's been going on. First of all, what kind of surprises me is that most people don't understand that the QSA isn't just a water transfer contract between IID and San Diego. It's a suite of about 35 agreements. Some of them might not even be agreements. They're letters or letter agreements. A lot of the parties to the QSA are not IID. There's all kinds of agencies. There's the Fed, there's the state, there's Indian tribes, there's other agencies. The first 13 of the agreements that are listed here, 1 to 13, are the agreements that IID sought to validate in the litigation. The remaining of the 35 agreements here were not part of the litigation at all. I would assume that they are valid. There are various issues now raised as to the fact that we have some agreements that have been invalidated and a lot of agreements that were validated. They were validated by operation of law because they weren't challenged. Those other agencies didn't see fit to file a lawsuit because they didn't think those agreements were going to be challenged. But the point of showing all these agreements is that the QSA is much more than a water transfer. In many ways, it's a system in which various agencies that use Colorado River water operate, the way they exchange water between them, the way the federal government and the state government work with those agencies. And there is a lot at stake with regard to the QSA, besides what's at stake for IID and even San Diego under the transfer. As Dr. Brady mentioned earlier, the federal government is taking the position that their agreements are still in force, that the operating agreements that were built upon the QSA that deal with the agencies that utilize Colorado River will be enforced, whether they're valid or not. There's like a delay between when I push the button and when something happens. It's freaking me out, but okay. One of the agreements of the 13 that we sought to validate was called the QSA-JPA agreement. That was the agreement that was the primary subject of the court's discussion, so I'm just going to make a few points about that agreement. It was authorized by a statute. The statute said that the state would do what they do in the agreement, and it authorized the state through DF&G to enter into the agreement. It's the agreement in which IID, CVWD, San Diego, and the state create what's called a Joint Powers Authority. It's a sub-entity that's combined by the various entities. And with that authority, they mitigate environmental impacts caused by the QSA, not just to the Salton Sea, although everybody talks about the Salton Sea, but impacts that could occur as a result of the QSA. They mitigate impacts of our drain use. They mitigate air impacts. They mitigate impacts with regard to endangered species. And what the agreement says and what the statute said was that IID, San Diego, and Coachella would each contribute in total $133 million present value to pay for that mitigation. And if all that money was expended, the state would pay the rest. That agreement also requires the three entities, IID, CVWD, and San Diego, to put money into what was called the Salton Sea Restoration Fund, which was created by another statute. And the agreement says that once those entities put that money into the fund, they would be indemnified for any other obligation with regard to the restoration. That was the agreement that the judge focused on, and we'll talk about that a little bit later. Just real quickly, when we talk about the QSA cases in Sacramento, we're talking about more than one case. We're talking about various cases that were filed, most of them down here, but in some other places, that were all coordinated together up in Sacramento before Judge Candie. There's a list of the active cases. Here's a list of the cases that were dismissed. There were a lot of cases that were filed that never made it to the end of the QSA coordinated cases. Some of these cases are on appeal. Some of them were, the dismissals were affirmed on appeal. The court made 147 rulings on contested matters before the trial. It dismissed 5 of the cases and a bunch of cross complaints. Some of the rulings are helpful for IID. The county argued that under water code sections that deal with the wheeling of water, that they had a role with regard to the QSA water transfer. And the court said that the county did not have a role. That the QSA transfers didn't violate those wheeling statutes as to the county. There were allegations that IID didn't properly serve its validation summons. The court said no, it did. There were allegations that IID did not comply with Prop 218 with regard to the QSA, and the court said no, it did. There were allegations that the QSA requires the state to restore the Salton Sea, and the court said no, it doesn't. There were allegations that the IID approval of the QSA was not a majority vote, and therefore it was not appropriate. And the court said no, the approval was fine. There were allegations about various conflicts. One of the pretrial allegations that was dealt with was that there was an allegation that Lloyd Allen, because he had a role on the Colorado River Board, had a conflict of interest, and he couldn't vote to approve the QSA. And again, the court said no. The QSA coordinated cases were intended to be a 4-phase trial. That's not the way it happened. The first phase dealt with validity of the agreements. It didn't deal with the environmental issues. The second phase, which is called Phase 1B and 1C, and third phase, were supposed to deal with the environmental issues. The court is apparently not going to move forward on those phases. And then the fourth phase has to do with 2 separate actions that were brought together, one by Meyer, and one with regard to the Western Farms purchases. And apparently what's going to happen with those phases, the Meyer case has been dismissed, and it appears that the court is going to send the Western Farms case back down to Imperial County to be tried if the parties wish to move forward on it. There were 11 days of hearing. The administrative record had about 330 CDs of information in it. IID's record was more than 500,000 pages long. This was not a trial in the conventional sense that most lay people think a trial is. There was no testimony. There were no witnesses. The evidence was the administrative record. The people who appeared at trial were lawyers or parties representing themselves, and they argued for 11 days. They argued, they cited to the administrative record, and they argued some more. They filed lots and lots of briefs, trial briefs, responding briefs, follow-up briefs by all these different parties. The court issued a tentative ruling on December 10. It vacated the environmental phases of the trial at that point. On January 13, the court issued a 52-page statement of decision, which is what most people are talking about. In the statement of decision, the court indicated that it was going to validate, it could rule on validation as to 12 of the agreements. One of the agreements, 13 on the list that I showed you earlier, is the CVWD flooding settlement. It ruled that it would not validate or invalidate that agreement, that it was not subject to validation. The other QSA agreements that I showed you on the list, the remaining of the 35, are not involved and are validated by operation of law. The court's ruling as to the QSA JPA was based on constitutionality. Section 9.2 of the JPA agreement talks about the state's obligation to pay for environmental mitigation in excess of the $133 million present value. It says the state's obligation is unconditional contractual obligation, and that it's not conditioned upon an appropriation by the legislature, and non-appropriation is not a defense. The court deemed that that was unconstitutional under Article 16, Section 7 of the California Constitution, which deals with the necessity for appropriation for certain types of expenditures. A lot of time was spent arguing those points. The court did not rule on Article 16, Section 1, which was also argued by the parties, and that relates to what's called the constitutional debt limitation. So basically what the court did was it found paragraph 9.2 of the QSA JPA agreement was an unconstitutional promise by the state. The court didn't make any rulings as to constitutionality, unconstitutionality as to any of the other agreements. But what it said was that the board, the IID board, would not have entered into the other 12 agreements had they known that the QSA JPA was unconstitutional and invalid. So it thereby, based on that reason, invalidated the other 12 agreements. It ruled that it did have jurisdiction over 3 of the agreements, which the federal government was a party and could rule on that. And then the environmental challenges, like I talked about before, they never got heard. The court said that the validation phase was over. There was no reason to rule on the environmental challenges. That could be done later if necessary at some other time. The court made some other trial rulings that are helpful for IID, and they're in the statement of decision, and they're cited there. The court ruled that IID is a public agency. The court ruled that IID has the authority to approve the QSA. The court ruled that in approving the QSA, IID did not violate any trust obligations, any fiduciary obligations, any obligations between a trustee and a beneficiary. The court ruled that IID, and not the landowners, hold state water rights and federal contract rights for Colorado River water. The court ruled that IID was not required to allocate water to the farmers at any time or prior to approving the QSA. The court held that there was nothing about a veto in the JPA that made it illusory. The court ruled that conserved water transfers can be possible without reducing farming activities. And lastly, the court ruled that there were no conflicts between IID's outside attorneys or their general counsel or their consultant that would invalidate the QSA. Those are all in the statement of decision, and they're cited there. The court also denied a lot of requests that were made by some of the parties that are helpful to IID and its understanding of what went on here. There was a request that the court mandate a water bank for the landowners. That was denied. There was a request that the court determine that the farmers own a proportionate share of water and the proceeds from the water that went to those transfers. That request was not granted. There was a request that the court mandate that IID make an accounting of trust assets, assets flowing from the water. The court didn't do that. There was a request that the court mandate that IID account for water and determine how much water was available to each acre of land within the IID service territory. The court didn't do that. There was a request that the court determine how much water, what volume of water the Salton Sea should be entitled to. The court didn't do that. There was a request that IID be replaced with some other trustee of the landowner's water rights and water supply. The court didn't do that. There were requests that IID pay money damages to these plaintiffs. The court didn't do that. And there were requests that the court recognize that the landowners were the owners of the right to Colorado River water, and the court didn't do that either. Where are we now? In the January 21st, 2010 status conference order, the court ordered the parties to brief its proposal to sever the Meyer case and the Western Farms case. Now, Meyer's been dismissed, so that's not an issue. And the court set a hearing for February 11th to discuss the judgment. It's my understanding the court set another hearing for parties if they wanted to file motions for attorney's fees. That hearing date has been vacated. So the proposed judgment of the court would declare that 12 of the contracts, 12 of the 13 that are on that list, except for the CVWD settlement contract, are void and invalid. The court did not validate or invalidate the flooding settlement agreement. There's no injunction against transfers in the proposed judgment. The court dismissed certain cases as moot, and it said that it would stay judgment for 30 days until the time for parties to file appeals expired. Now, judgment hasn't occurred yet. I anticipate it will occur soon. There's been some discussion about IID obtaining a second opinion, to which I usually respond, second opinion as to what? There's a lot of things going on here. The board directed the staff to obtain a second opinion with regard to the direction that we're taking. We contacted Stuart Somack, who's a principal of Somack, Simmons & Dunn in Sacramento. He's a very well-known water law attorney. He's very familiar with the environment with regard to water issues, the legislature, the executive branch, and the other agencies. He used to work for the federal government. He has taught. He's familiar with environmental issues. We asked him to review any of the files that he wants to, and he has just about the entire trial file at this point. And starting with these three questions, as you know and as Dr. Brady explained, the board passed a resolution to appeal the QSA judgment and seek a stay. and then the board is interested in trying to get the benefit of the bargain that the district made through whatever activity is necessary, be it legal, legislative, administrative, or some combination of all of them, or negotiated. So the question for Mr. Somack is, should the district appeal? He's going to have to look at the trial matters. He's going to have to look at the judge's ruling. If we appeal, should we seek a stay? And does it make sense to achieve what we thought we had bargained for through those methods? Mr. Somack should be prepared to appear at the next district board meeting, which is February 9th. That's a 5 o'clock information meeting. And he will be available in open session. You can all show up and you can grill him and have a good old time. And I'm sure you will. The last issue that I was asked to talk about is the price dispute transfer. And we probably would have been discussing this sooner, but it got overcome by other events with regard to the QSA. This settlement was eventually reached primarily with the help of Dr. Brady, and I know Greg Broking was involved too, and I might ask Greg to make a few comments when I run through this. In the San Diego transfer agreement, which is the 98 agreement revised up to the revised Fourth Amendment, there was a deemed schedule, in other words, a laid out schedule for 15 years of the price of water. The parties could follow that schedule, but either party could elect, after 5 years had passed, to go off that schedule and go on a schedule which is called the base, or go on a price formula called the base contract price. The base contract price, as I'll talk in the next slide, is based on met rates, and the intent was that San Diego would pay rates similar to what they would have to pay from had they obtained the water from Met. The IID parties that were bargaining the QSA at the time knew that Met rates were going to rise. They knew that rates in general were going to rise, and they felt that they could get rates that would be better than what would be on the deemed schedule. In 2008, San Diego elected to go off the deemed schedule and use the base contract price schedule. In 2008 and 2009, there were attempts to settle disagreement with San Diego about how to calculate the base contract price. That disagreement was made more difficult because Met changed its rating structures, unbundled its rates, and charged multiple rates that would apply, and we would have to go through all those rates and determine what the appropriate base contract price would be. We were unable to reach a resolution with San Diego. We set a compromise rate in 2008 and 2009, and finally, when we couldn't resolve it, we requested arbitration under the agreement. And a day before the arbitration trial, we finally reached a settlement. The settlement prices were almost the same as what we were asking for in the arbitration, just a little bit less, and much further away than what San Diego was arguing at arbitration. Okay. There we go. Under the deemed schedule for the first 15 years, and we're in year 8, the price would be $327 an acre foot for water transferred to San Diego. As you can see, the deemed schedule started at $258 and goes up to $420 at year 15, at which point it converts to the base contract price schedule. Under the new agreement that Dr. Brady helped to finalize, at year 8, which is 2010, instead of $327, the price is now $405. At year 13, instead of $390, the price is now $624. The price rises from $405 to $624 during that time. Then from year 14 to 32, it stays at $624, but it goes up by an inflation index. In addition, San Diego agreed to make a lump sum payment on December 31st of last year, which we received a $6 million. That's to pay for the fact that they underpaid in 2008 and 2009 based on the settlement. And in addition, because the board directed Dr. Brady to see if he could get some more upfront money to help pay for some of the necessary conservation for the QSA, they've agreed to front $50 million in October of next year. And there's a clawback on that 50, but the point, if we didn't get the $50 million, then that 624 might be a little bit higher. But it was thought that it was most favorable to IID to have that money up front sooner rather than later. just to give you an example, in 2007, we transferred 50,000 acre-feet to San Diego. We got $296. In 2015, we would be scheduled to transfer 100,000. We'll receive $624 an acre-foot. That's the difference in the revenue. It's pretty substantial. That does not even include the $50 million payment we'll receive in 2010. Revenues would quadruple by 2015. Now, one of the issues that was argued pretty strongly with San Diego was that their concern was, we're going to give you a $50 million upfront payment, and then the judge is going to invalidate the QSA, or the transfer is going to stop, and we're going to get stuck. We understand that you'd like to front some of that money. So what we negotiated is what's called a clawback schedule. In the first couple years, if the QSA is stopped, they can get a substantial portion of that money back. But after a couple years, as you can see, even if the QSA were stopped, we would keep a substantial portion of that money. It's important for a number of reasons. If we did not move forward and get a stay right now on the QSA, we would lose the $50 million payment next year. We would lose about $28 million in revenues based on the projected transfer next year. We would still have to pay about $5.5 million for following contracts that we've committed ourselves to, although if there's no transfer, we wouldn't even be transferring that money. There would be no following contracts after that. We would save a couple $1 million in QSA environmental expenses, but it doesn't really make much sense to stop at this point with this much money available to us under the table. As an example of the new pricing, in 2015, San Diego will get...
On the table. On the table.
Oh.
On top of the table.
Did I say off the table?
No, you said under the table.
That was a Freudian slip, wasn't it?
Yeah.
In 2015, San Diego will pay to IID $62 million for 3% of our entitlement. That's $15 million more than we would receive if every agricultural user purchased all the remaining water that was available. That's a big difference. One other point I do want to make is that the environmental mitigation activity that's going on, for instance, the managed marsh, is not only addressing impacts on the Salton Sea from the QSA, but it is the only reason that we have a permit to operate our canals and drains. If we don't move forward with that activity, we're not going to be able to operate our canals and drains until we get that permit. It's a nice deal to have two other agencies paying a substantial portion of the cost to do that work. There is a lot of environmental activity that's going on because of the QSA that is not just related to the transfer of the Salton Sea. There's endangered species protection that would be valley-wide. There's mitigation activity that would be valley-wide. And so there are a lot of benefits from the QSA that don't specifically relate to the Salton Sea or the water transfers as well. So that completes my portion of the presentation. Thank you.
Okay. Just once again, I imagine there's still some hard copies of the presentation if you want them over on the side. Next is the public comment period. And as I mentioned before, we won't be able to answer all the questions. We will be compiling a written record of all the questions and creating detailed written responses. Additionally, I think this is true, Kevin, we're going to be doing a frequently asked question ad series in the paper. We're also going to be putting that on the IID website. We're going to be doing a QSA continuing progress report. I think that's the title we're going to call it. But it's, again, to answer questions, we're going to hold more workshops. We don't know quite what the frequency is yet until we get a couple more weeks out. And then at the end of the public comments, we're going to reserve time for the board. So, Mr. President, you probably have a big stack there?
We'll begin with public comment. First one is Mr. Benson, Stephen.
Hi, Steve Benson Brawley. Sorry my dad couldn't be here. One question he wanted me to ask, and I want to ask it too, is how much does the IID anticipate the appeal will cost? Also, how much does the IID lose when the QSA stopped as far as cash coming in? I saw the payment schedule, but also for the budget, how is the budget affected? And will the water continue to flow or not? And then how do the permits get affected? And what is the process that the different agencies will go through to either shut down the water supply or not? Kind of impacts our cropping schedules. And then a question to the directors, and I know you're not ready to make a statement, but do the directors support the QSA in its current form, or do you anticipate some sort of bargaining going forward? And will there be a process that the public can comment on or be involved? There's several different groups that are involved, but really they don't represent the entirety of the valley. It's the board putting a few people on a board, and they get to talk internally. But as a young farmer, it's important to me. So that's all I have to say. Thanks.
We're taking down all the questions.
Mr. Larry Cox.
Larry Cox, Farmer Brawley. A couple of questions. And is the IID casting a wider net than just looking at SOMAC, or was SOMAC the first choice? You know, I have a little bit of concern when Stu came down and he said that the IID was allocating water because they were delivering all that everybody had, and that sounded to me like he gave an answer. You know, he gave an answer to answer the question with how they want the question answered. And my concern would be that he's going to come down and say, okay, what kind of answer does the IID want? And you know, pay him to tell you what you want to hear. I kind of echo Stephen Benson's question on whether or not the directors support the QSA in its current form. We do need a QSA, and the current QSA does have a lot of valuable pieces to it, and we don't want to throw it out. Speaking personally, I think it just needs to be, there's lots of areas that are very inequitable to the Imperial Valley. I was at the Hertzberg hearings, and that was basically a one-sided dialogue there. And I would hope that the IID would take the opportunity to address the shortcomings and flaws in the QSA. And one question that I would ask whoever you get a second opinion from is, should the IID strive to renegotiate the areas in the QSA that are flawed, and was the QSA a good contract for the IID and the Imperial Valley? Thank you.
Michael Cox.
Good evening, Michael Cox of Brawley. I just want to echo my brother's comment. It's very important that you get a second opinion. It has been a long and arduous process, but I really think it's valuable to have someone who has not been part of that so-called dream team to weigh in on this and make sure that you are still pursuing the right path. I think the same issues are still at play, and the benefit that you got from the QSA of having a settlement or a deferment of challenges to our reasonable beneficial use that were being posed by the Bureau of Reclamation, by Metropolitan and Coachella. That was probably one of the main reasons to sign that QSA and the water transfer. That and the protection you thought you were getting from the Salton Sea liability. I don't think you're that far away from finding a way to maintain this or find a way to satisfy the judge's objections. You do still have Also, try and hang on to those environmental benefits you got as far as protecting the district's operations and their drain maintenance. Now, there were flaws in the QSA. You gave too much water to Coachella and too cheap. And there was no upfront money. Now, you seem to have found a way to get some money to pay for the system conservation through this price settlement agreement you have. But that is conditioned upon keeping this QSA and the water transfer from being overturned. So I'd hold your course, keep your options open. I don't have a problem with Mr. Somack. I agreed with his statement that the district was allocating water. It just wasn't a form of allocation that some of the others challenging these agreements wanted to have in place. And I like the layout of decisions that the judge laid down that confirmed IID does hold the water in trust and has the authority to enter into transfer agreements. So I look forward to seeing what Mr. Somack has to say. Thank you.
Rodney Foster.
Rod Foster Brawley. Have a little concern. You talk about transparencies, you go through your chronology, and QSA essential protections. It's not until I get to number 5, which is next to the last, that anything is said about water rights and protecting our water rights. For 7 years, all I've heard out of the IID is the QSA had to do with water rights. And when I read number 5, it's ensuring a revenue stream, not protecting the water rights of the landowners that you represent. Yeah, I do think that a second opinion should be very forthcoming, and probably somebody even more than Somack. Somack has been employed by the district in different positions for a long time and doing different things. But I'm very concerned that this board, and probably not so much the board as the staff, what was your plan B? Or was plan A simply it and to keep litigating and there was no plan B until all the money's gone and you have to do A? I think a lot of people in this valley would like to know what your plan B is. Thank you. Or even if there was a plan B.
Orby Hanks.
Orby Hanks, Raleigh, California. I basically echo my fellow Raleighites on the second opinion, but Plan B was mentioned. You know, we've known this thing was coming along. We've heard people talk about the QSA having flaws and whatever, but it's the best deal yet. And now we've been in this turmoil mode for almost a month now. And Rod mentioned Plan B. I would have mentioned it as an alternate plan, as well as a second opinion. Now, I'm going to be blunt. You guys know I'm blunt, so I won't disappoint you. Dr. Brady, do we have a second or an alternate plan if something goes wrong with the current system we have?
We're working on alternatives.
We're working on alternatives.
Yes, we are.
Okay, that is...
I didn't mean to answer a question, but
That's all right. I kind of expected that. I appreciate it. So I'll go a little bit further. We have observed what has happened with this board and And you and I have discussed this, so I'm not going to tell you anything that I haven't told you to your face. We've watched your mode of operation. We were here with us for 2 weeks, and you split a unanimous board. And since then, we've watched the way this board has voted. It's been a 3-2 situation. Whenever there's been times for discussion and whatever, talks have been with the IID that we have been dictated to of what it will be, and that scares a lot of us. I do not have any acreage. I do not have a water card, but this valley exists on its program. And if we are going to go forward with this thing, I think we need that time of exchange of ideas. We don't need to be talked down to. Some way or another, I've been getting papers that have come through to my office, Google Goggle or Boondoggle or something or another. And I guess that's one way of calling people uncomplimentary names and telling them whatever it is. But that kind of situation is not going to help. My question is, when we do have, or if we do have a meeting, will it be a meeting to where that there will be an exchange of ideas, or we will be spoon-fed? And will you accept those, and this is to you, Mr. Brady, will you accept the opinions of others, or will we be held to a three-man vote? Just what kind of deal will we be going into? Now, I know that this is over my head in the way that the process goes, but it's not over my head on what is fair, honest, and reputable. Thank you.
Rusty Jordan. Rusty Jordan.
From Brawley.
From Brawley.
I got a couple comments to your presentation. If you go to page 17 and look at the top bullet point, and there says there's a meeting of the minds, and that isn't really fully discussed. You might want to read that. And then there's no invalidity, and the invalidity says that John Carter, one of the 1090, just the bottom bullet point on 17, it said that John Carter was the only public official. So it didn't have to go to whether Rodney Smith or David Osias were conflicted. That's page 17 of your presentation. I probably am the only one in this room who sat across the courtroom from David Somack, and maybe the only one who had a comment come back from appellate court that the Jordans should go and file. Wouldn't be surprised if the Jordans filed an appeal because the expert witness that David Somack presented in trial that was pivotal in the decision in the favor of the city of Lompoc provided directly contradictory testimony in another trial, and not too much longer. So if that would be, that's my only comment to him. Then, so when you're getting a second opinion, I think you might want to look and have them give you an opinion about the attorney's conduct, because you paid them a lot of money. And if you look, well, I'll get to some other parts of it, and what's the quality of the decision? What's the likelihood that it'll be turned over? And there's a big part about in the decision that was not discovered in your bullet points, that the decision that on page 7 that the district misled the local court and had I think contract M was dismissed, It also said on page 17 that the approval process is relevant, even though he didn't have to get to it. And because of the Hyde email, we discovered that the district was not aware of changes made in the contract. And because the contract was unconstitutional from the judge's point of view, he didn't have to say that the contract was thrown out because of the process, but there's a process issue that would very well negate the contract. Now, I'm sure that David Osias can figure a way around the contract around that. The real pivot of the whole trial was the state obligation is an unconditional contract obligation to the state, and that put them in a problem of being over, being over their budgetary limit of $300,000 a year. And then there's a real interesting thing on page 38 that you should read from the state attorney, where he declined to comment on the state, whether the state would elect to fund the Salton Sea if they didn't have any money. And I think you guys were going through that a year or so ago. Then I'd like to talk for a second about the cost of security. I really don't have a problem with the San Diego deal. I think that the San Diego deal will ultimately provide very good money. But what we did do is we sold $75 an acre foot water to Coachella, 100,000 acre feet a year. And we continue the MWD deal, which would normally expire in 2024, which I might even live to see, giving us $17,500,000. If they paid the market price, they'd be paying $82 million. Now, Coachella has the best of all worlds. We're going to take water that would have normally gone into the Salton Sea and send it to them, and they're going to deliver it and irrigate with it. And if they have 80% efficiency, which I'm sure they will claim, only 20,000 will go to the sea. That means they'll be affecting the Salton Sea without running water into it. Then they have an overdraft problem, so maybe some of that water that would normally have run off for us, if we'd been more efficient with it, would go into their groundwater. So they might not ever put any water back into the sea, and they get a free ride on the cost of mitigation of the sea, on whatever the contract amount is, which isn't very much. Then, if you add that up, what we did is we gave away $4.4 billion in revenue, and I'm sure that your number crunchers will find it's probably more like $3 billion, because I just did simple math with all the years, and the thing ramps up and ramps down. But we gave away $3 billion, and we're going to receive something like $1.6 billion. So we would have gotten $6 billion. What was it? Anyway, we would have gotten $1.6 billion, and we'll get it from this contract with these two people, and then, but instead of that, we could have gotten $6 billion, and that was the price we're paying for giving them cheap water to get around to get to the San Diego deal. And I know that our attorneys, or your attorneys, may be expensive, but they're not that expensive. You could have litigated and figured a way around it and not paid them. Now, if you look at the cost of the Salton Sea, on the simplest way, $3 billion, that's what the state said it's going to cost, to do nothing, to put gravel out, to have no fancy lake, no good views, nothing. If you take 68 years left, that's $44 million a year. If we're just simple math, and then you could crunch the numbers and work differently, that's $110 an acre foot for every acre foot that doesn't go into the Salton Sea that's going to cost somebody. So you can add it to the price of the deal when you renegotiate the deal. Mm-hmm. So when we protected our rights by giving cheap water to Coachella and met, we chose not to litigate the issue. We're going to get 30% of market on today. 30% of market. We'll lose $4 billion for the Valley on the deal to not take on the fight to find out what it is. And the backside of the situation is, if you litigate and lose, you still have a Supreme Court water right. They take away your water. You get a 417 and they give you 2.8 million acre feet. Coachella gets the water. The sea goes down. Mr. Brady goes out to the west side, east side, out in that exposed playa, rents the ground. You put 100,000 acres into production, use 400,000 more acre feet. You get a contract to buy those guys out. You offer the contract to the cities. They can buy them out. You played poker. You made billions of dollars. $4 billion for the Valley is the potential win versus the route you're taking. That's about all I got to say for now. Thanks.
Moving on to Craig Morgan.
I'm here on behalf of Jimmy Abadi, and I have a letter to hand out as well as some short comments.
Thank you.
Thank you. How you doing, Craig? Pretty good.
Thank you.
Thank you.
There you go.
Thank you. Good evening. I think the news that the board is soliciting a second opinion is good news. I have a couple of recommendations there is that I think the contract should be directly with the board members themselves as opposed to staff. And during your closed session discussions about his recommendations, that that he's there talking to you as opposed to providing recommendations to staff, which then provides recommendations on to you as to what he said. You're also getting a legal opinion. I'll remind you what that means is that he's going to be looking at whether or not the legal requirements have been met, whether what's been proposed is legal. He's going to look at the judge's decision. He may give you some ideas as to whether or not you're likely to prevail on an appeal, but he's not going to necessarily give you an estimate or a judgment as to whether or not you can have a better deal. And that's something that's going to rest with the board of directors, is based upon the legal standing. Can you still get some of these things that you need to get implemented? And maybe you need a bookie instead of an attorney to give you some of those that kind of advice. In January 5th, the board passed a resolution to appeal Judge Candy's ruling. Based upon what I've heard today, it sounds like you're stepping back from maybe that to get a second opinion before you take the next step. If that's the case, then I would applaud the directors. When you passed that resolution, I was a little surprised that two of the board members voted to appeal and perpetuate the QSA. In particular, Ms. Mendoza and Mr. Menville, you've had a long-standing pronouncement that you oppose the QSA, so to jump right up there and keep pushing it was kind of a surprise to a number of us. I'd like to say that you can't hide behind the prior board's decision back in 2003. The decision for the QSA at this point lies firmly in your laps. And I would also add that the decision back in 2003, I see one of the directors here that made the swing vote, what they thought that they were winning is different than what you know of now. And on top of it, after October 2nd, when the board made their decision, there were some wording changes that were key wording changes made to the agreements, apparently made without the board's knowledge, and that was to give the state a veto power over funding for mitigation and or restoration of the Salton Sea. That's something that this board ought to investigate as to what that circumstance was and why that happened, and whether or not you would agree to give the state some kind of a veto power. And the language says something that, their approval for mitigation won't be unreasonably withheld, but when it comes down to dollars and cents in the future, it's written in the contract. They have a veto power. Back on the chronology and the history of how you got here in the first place with the QSA, there's a long-standing history going back 20, 30 years. I think it's important to remember when you talk about if we don't send them water to the coast, that they're just going to take away our water because we're wasting it. There's some statements there that have been made in the press by some of the staff and by some of the directors that just aren't simply true, and it goes back to the state water right orders in the early 80s, in the late 80s. The state didn't say that you were wasting water in Water Right Order 8820. It said the quantity of use was unreasonable in light of the benefits of conserving it, certainly when there were parties standing by that were willing to pay for it, meaning Metropolitan Water District. Back in 88, the district had put together a water conservation plan. They had envisioned conserving 367,900 acre feet of water, and that's incorporated into that state board water right order 8820. And at that time, the district was only envisioning transferring 250,000 acre feet of that water. They weren't going to transfer the whole 367,900 acre feet. The rest of it, they envisioned they would need in the valley. Certainly that need exists today. So we find ourselves where back in 1988, the board was envisioning transferring 250,000 acre feet outside the valley, and it's avalanched into 500,000 acre feet. And it's left you no water remaining here at this point for additional uses inside the valley. And the cost of conserving that additional water is getting exponentially more expensive. You're transferring off the simple, easy stuff, but when it comes to actually conserving additional water to meet your own growing industries, it's a lot more expensive. That's something that the board ought to revisit when they ponder where they want to perpetuate the QSA. I know you have a lot of speakers here, and the rest of the comments that Jim's provided are written in that letter, and so I'll bid you adieu and let you get on with the rest of the speakers. Thanks.
All right. Thank you, Craig. Bruce Kuhn.
Right.
I gotta get my leg irons off.
Good evening. Interesting times we live in. First, I want to say I am most thankful to be able to be here in person, as my phone's been ringing here the last week, and people are concerned that there's a segment of our citizenry here that are telling everybody I'm going to jail for corruption for actions I took here on the board. So I'm glad that I'm shackle-free, handcuff-free. It's nice not to be incarcerated. Having said that, and I will pass this admonishment on to those who are perpetuating this, if you stir a goddamn rattlesnake, you better use a long stick or you're going to get bit. That said, Stella, you voted no on it. John Pierre, it was too much water, it was too long, it wasn't enough money. You have an opportunity here to make all those campaign promises you made that it was going to be, you could have made a better deal. I have seen a lot here this evening that I already knew. I received many phone calls to shed, I call it corporate memory on issues, and I have stood by and seen things misinterpreted, certainly misrepresented, and on numerous occasions just makes me want to puke. On page 16 of your presentation says basically the contract would not have been issued into had we known that the state of California was not going to be responsible for the restoration of the Salton Sea. And I can certainly tell you, being the swing vote, that Mr. Menville let everybody in the world know that it was my baby. This whole thing's mine. I did it all by myself, too. Anyway, I met with Don Cox down at his office there in Brawley. That's that Carl Jr. And I met with Don down there on several occasions. Anyway, one of his biggest concerns was that the IID or the county be responsible for the mitigation to the Salton Sea. He didn't have a problem with us participating as we did, and I agreed with him 100%. There's not enough money in this valley, nor will there ever be enough money in this valley if we're responsible. It is a black hole. If this board, in any way, shape, or form, lets the IID or the people of this county become responsible for that Salton Sea, you will be personally responsible for the death of this farming community. There's not enough. They will not let you put enough money in there. The state, when we went into the governor's office and Richard Katz said, well, the state will take responsibility for that. And I said, hey, we have something to negotiate for. Because the one thing that Don did not want to see was the IID or the people of this county be responsible for that sea. And I can tell you now, without reservation, if it had been any other way, I would have voted no on the QSA. I also would have voted no on the QSA if the Farm Bureau had taken the vote the night we voted on the QSA, and I was over there at the meeting. Give me a sign, tell me what to do. If you truly don't want this, vote tonight and let me know. I walked over here, not mentioning any names, but asked gentlemen, did they vote? No, it's too close. They refused to vote. You're going to have to make the decision on your own. Oh, crap. Well, here we are, but the Farm Bureau had an opportunity to stop it. The Salton Sea, if someone else wasn't going to be responsible, I'd have voted no. Now, having said that, you now, and it was mentioned earlier, I don't remember who, I don't recall, you now have an opportunity, especially you, John. You have an opportunity to make this better. You don't have this board. You don't have the federal government breathing down your neck. My good friend Feinstein, that you blasted me for. I don't know whether you people are at all cognizant, in fact, of the letter that woman sent down here when I was president of the board. I know Rudy Enigas does. He works for the paper. I know Rudy knows about it. Andy's out here. He knows about it. What it said was, if you don't put this deal together, I will bring the entire weight of the federal government to bear upon you. And that's when she solicited my little response, you bureaucratic gas bag, pig-eyed sack of crap.
Oh, Bruce.
Threatened us. We were trying to do constructive dialogue with the federal government. Our own senior senator for the state of California comes out against us. We had no allies. You people, up the presentation today, the federal government, they're satisfied with what they got. So you don't have them breathing down your back. You won't get one of those nasty letters, John. She may invite you to tea. Now, the state, they consider it, oh, there's going to be one. The only thing that scared me was even if it takes administrative. Now, I'd be a little worried about that if they want to just jam it down your throats now, but you have an opportunity to change it. for the better. You don't have the state on you. You don't have the feds on you. You don't have Coachella on you. You don't have Metropolitan. You don't have San Diego. You don't have the Indian tribes on you. Think about it. I feel like one of these old cowboys just got the crap shot out of him, so you guys could come in behind and do the farming. Guess what? It's not always great to be the pioneer, the first one out there. But I took my shots. The paper castigated me, eviscerated. This newspaper, on any given week, Loyal and I were just about that much higher than dogs. And they, over and over, we have an electronic poll going, and people believe they have less water rights now than when you put this thing together. And they broadcasted that on a routine basis. Now I'm hearing, well, gosh, this thing's giving us rights. I think Dr. Brady had a very eloquent letter in there explaining the strong points on it. But that's not what I heard for 2 years. Now, having said that, you have an opportunity to make it better. Stella, you voted no on it. John Pierre, you told everybody you would make it better. You've got an opportunity now. This board does. Do it. You've heard from people here. Incorporate some of them in your next decision to go forward. Fine-tune this thing. Get a better deal. Look at the pressure you don't have. Look at the pressure that's been taken off of you. You have an opportunity to make it better. If you don't, then I believe it is an opportunity squandered. Thank you.
Thank you, Bruce. Gilbert Gonzalez. Gilbert Gonzalez.
Oh, I thought you'd give a change.
Good evening. Gilbert Gonzalez, first time speaking. A little nervous, but I'm going to try. First of all, always grew up believing this was an ag community. I always thought that the board we had here would be pro-ag. I'm not so sure about that anymore. Had a few, I witnessed firsthand that maybe it wasn't as pro-ag as I thought last year. I think some of the decision making is affecting the farmer to where it's being real difficult to do business, and I just got into farming, so it's kind of, I don't know why I did it now, but I was trying to change my mind. Anyways, I'm mostly involved with trucking, and last year when I started farming, I noticed that farming, the trucking, everything in the economy here went hand in hand, and I believe declaring last year an SDI year so early on was maybe not the best decision. I wouldn't want to be the one making those decisions, but I can tell you firsthand that was pretty impacted my business pretty hard. It was I know it's Sudan business. I know some of the board members may not know what Sudan is, but whenever they want, we could give them a tour of one of the plants down here and kind of open their eyes. They'll understand what goes on. But a lot of people didn't get a job. A lot of vendors didn't sell. Businesses didn't prosper because of the Sudan deal alone. So I think that it's very important that the farmer gets upper hand. It is an ag community, and I would like to see it continue as an ag community. And I would like the board to, if they could, continue to support agriculture. And that money from farming trickles down, and then I don't have the words to say it, but I can, any day anybody wants to go, we could firsthand, and got workers calling me every day. I mean, last year, it made common sense to me that water wasn't, we weren't going to go over on water because we can get irrigators any day. That didn't happen the year before that. You could not find an irrigator, which meant they all had a job. That meant a lot of water was being used. Last year, you could call any labor company. Guys were calling me that I didn't even know, trying to find a job as an irrigator. So common sense told me, you know what, we're not going to be over. But you declared an SDI, and I think that really impacted my business, and a lot of our employees and a lot of people's families pretty negatively. And I just want to let you know that. And if any further decision making, you can take that into consideration. I'd greatly appreciate it. And so my only question is, why wouldn't the board be more pro-ag in a community that's so pro-ag? And if you could let me know if it's not going to continue to be pro-ag, you know, I'd like to know that and maybe have an application or something. Thank you.
Thank you, Gilbert. Rudy Maldonado.
Thanks, Rudy.
Greetings, ladies and buckaroos. Doc Brady, that was a real good letter you had on Saturday. Too bad it wasn't on Sunday. What most of us would call an executive summary with a outstanding timeline. Second opinion, ladies and gentlemen. Just a reminder for some of the board members, Stella's aware of this. Director Andy Horn asked for a second opinion. I think it was in 2002. The board gave him a 5-0 vote, and he brought to the table Stu Somak. Okay, Stu Somak is well aware of the IID legal team. Therefore, I think he has carnal knowledge of what was going on. Okay, to come back to the board and let the board know that we were on the right track on this QSA. Of course, Andy didn't like that decision, but nonetheless, that's what it was. On your resolution 2/2010, you're asking for a transparent process. It's already tainted with his presence. So if you could restart that with another legal firm, I think it would be better for the whole valley, okay? Because you want to protect Stu, he's a good attorney, what have you, but the thing is his presence is not going to give us what we want. And I think that's what the 5 of you really want on that second opinion. On my travels, on the QSA, everyone I've spoken to, everyone, they're asking, do not reset the start button on the QSA. Whatever you need to do, massage it, tweak it, tenderize it, don't restart. Try just to make it better if you can. And I'll leave you with that. Thank you.
Thank you. Mark McBroom.
Mark McBroom, Calapat, Pearl County Farm Bureau President. 2 things. We're glad to hear that you're going to solicit extra second opinion. We'd echo what we've heard here today, and thirds and fourths aren't bad either. The other thing is we're encouraged to hear about the additional workshops, and we would love to be in any of the process that we can be helpful at the Farm Bureau, and be in any kind of discussions that you are open to. We'd love to be a part of it and help get this QSA righted for the betterment of the valley. Thank you.
Thank you. Tony Ramos.
Good evening, everybody. My name is Tony Ramos, a Central resident. Members of the audience and members of the board, I started coming here around the year 2000, right before the QSA transfer. And back then I wrote a letter to the paper comparing Owens Valley and Imperial Valley because, as you know, or some of you may know, that back in the mid-20s or something, LA went to Owens Valley soliciting land to build an aqueduct. But the people there were told it was for their betterment, and they sold the land. To make a long story, eventually that's what they did. They built an aqueduct, and what happened to Owens Valley? Dried up. There was nothing there. And even though it's not happening here, I see the fact that the lack of water going to the Salton Sea could start something like that again, all because someone else came in and bullied us into transferring water. What the public knows about the QSA, all it knows is this. It says that people in the valley shouldn't be transferring water. People that live in the desert shouldn't be transferring water. and that the fact that the water was transferred, as some of these gentlemen in the farming community have said, the ones that benefit are the farming communities in the other counties, not this county. I have no problem with the farming community coming forth and stating their opinions and defending their rights to the water. But because I do not have a water card and I don't have land or water to go to, I can only tell you that my main concern is the future of our kids. What's going to happen to them after this board decides or doesn't decide between now and 20, 30 years from now what to do, or you have decided the future of our children? You know, most of us, like myself, who have been living, I just turned 62, I'll be 63 in November, but most of us are going to live and probably end up dying here. If I've gone out of the county in the last year 5 or 6 times as a loss, so I stay here about 80 to 90% of the time, except for visiting my daughters in in San Diego and Phoenix. And all I can say is that my budget that I have in my retirement has to be stayed close, because I have to keep up with higher water rates, higher power rates, to pay the attorneys that represent us to defend the QSA. Now that's an irony, because to me, we shouldn't have to pay anybody when we have our own attorneys here. Nothing against Mr. Garber or his staff or anyone in the staff of the IID, but at the same time, that's what we hired them for. But apparently, this guy Stomack or Sumac, I'm not sure what his name, and I don't mean to be funny about his name, is that he's been involved in this from the onset. And I'm not sure whether it's feasible to keep hiring someone that hasn't given you an answer after 10 years of doing the same thing. Last week I went to the Board of Supervisors and I told them about some issues I felt very strong for. One of them, I will be going this Tuesday, is this money they're spending to sue you guys because of the QSA. And one of their board members, White Eingruber, said that he was happy, to say the least, because this judge up in Sacramento area invalidated the QSA. Yet he represents us, the board represents us, and they're suing you guys, who you also represent us. And who ends up paying the bill? It's us, the public, and these gentlemen and these ladies out here. And that's why I say, I'm glad that I retired from the probation department after 35 years. I've always said I'm a go-getter and a big fan of being an American. Not necessarily a Mexican American, but being an American. I have served my country for 4 years, from 1966 to 1970 Air Force. But I come back here, and it was better for my kids, for me, when I came back in 1970 than it is for my kids right now, because I just went to another meeting last week of the school board, and they're deciding to make another school and spending $3 million on something that we may not need. How all this comes together is that I wonder, how does the board, the supervisors, how does this board sometimes, how does the school board think? Do they just ask us to vote for them at the time they need us to vote for them and then forget about us? What's the point of us coming here and making our pleas and deciding and asking you guys, listen to us if you don't? I think for the better part, the people that I supported, and I won't hesitate that I've supported Stella and Mr. Menville. I don't regret it one damn bit. And I used one word right there that I shouldn't have said, but I said it just like my brother Kunder said, a little worse than I did. But people, all I have to say is that what does our children, what do they have at stake here? It's what we decide for them. And I'm not going to get here and try to point fingers at my friend Mr. Morgan, because at least he's given me a couple of sacks of onions in the last couple of years, and I'm thankful for that. But really, my dad worked all his life for the farming community, and I worked up until I went in the Air Force. I have no cause to put them down, but it's how you can work for both the farming and non-farming community to do the best thing. And I don't think that the best thing is spending our money, what we put in the little kitty at the county and at the IID level, to spending on attorneys to get rich off of us. Thank you very much.
Thank you, Ms. Ramos. Eric Reyes.
Eric Reyes. Reviewing this, the articles you gave us here, and as we move forward or decide not to move forward, I guess, there's so many issues. There's also a great opportunity for you. If this water transfer is what we want, is what you want as a board, number 5 on your handout here, a revenue stream to fund needed system and on-farm water conservation improvements. Man, you can negotiate the heck out of that. Move us out of fallowing as soon as possible. Move up your on-farm conservation and system improvement plan tremendously. The $50 million you're going to receive this year, I mean, what's it earmarked for? Can you tell the public? I just found out about it. I guess it hadn't been announced. But that also asks a question. I want to know, what is that $50 million upfront money earmarked for? Is it for on-farm? Is it for system operation improvements to conserve that water? Because I've wondered throughout this whole process, and I've been involved for a long time, just like Mr. Tony Ramos. We were all here when it happened. Do we truly want to conserve water? I have to wonder that as the junk Iid Public, because there's so many tried and true ways to save water that we haven't. I've been here and I've asked you, why can't we bring back the tailwater box program? That's a guaranteed way to save water. It did it before. It'll do it again. It's not as so expensive as some of those on-farm conservation plans that was brought in the integrated water plan and so on. I mean, that's a tried true way. It's saved tremendous amounts of water already. And I asked some of the board members to investigate that and have not had a response at this time. But I hope that's something you keep in mind as well. That's an easy program to install. But my question is, this increased revenue also from the new negotiated price for water, is that being earmarked for water conservation, environmental impact mitigation? Because I agree with Mr. Garber completely. It's not Salton Sea that's causing all of the environmental impacts. There's so much more that we have to mitigate. And we already an impacted air basin out of compliance EPA-wise, and fallowed fields need to be mitigated to the best extent it has. And right now it hasn't been either from the IID. And that is causing issues with the APCD locally, getting more pressure from the EPA and from the state, from the California EPA for being out of compliance as well. And those are opportunities if you decide to go forward. I haven't heard anyone said you're not deciding to go forward. Maybe that's an issue we need to bring. And yes, it's true, Mrs. Mendoza and Mr. Menville were very outspoken about not having a water transfer. Is that still on the table for you too? We'll see. Time will tell. But I do know that the way it's been implemented, the QSA to date, has not been to our best benefit as a community, as a district, water district. And yes, there are competing forces, agricultural, industrial, obviously other issues, other interested parties who are kind of fighting each other over how this is going to be implemented and who gets the benefit of it. And therefore, we haven't provided a unified front to make this as best for everyone involved. I mean, I can say that without a doubt, following this QSA hasn't been implemented the way I thought. And I know I've talked to some directors that they would like to ramp up the effort of on-farm water conservation. Hasn't happened yet. They would like to ramp up needed system improvements where we're losing, you don't even know exactly, but in some of the meetings, as much as Arizona takes or Nevada takes, I believe, from the Colorado River, we lose that much unaccounted for in our system. I mean, that's incredible. That many acre feet unaccounted for. I mean, where are our priorities? We need to decide if you're going to negotiate any future water transfer, that you need to prioritize that, conserve that water, mitigate the environmental impacts, make sure the Salton Sea is conserved. San Diego wants your water. Metropolitan wants your water. Other people want your water. They need to pay for the Salton Sea mitigation. They need to pay for all the other environmental impacts, and they need to pay for our system improvements for water. I need to have more people involved. I mean, there's so much you guys can do. You guys are very competent. I think you have the best interests, but you're being pulled so many different ways. And I hope this gives you an opportunity to be in public, make a transparent process of it, take everybody's opinions into account, how we should move forward. And I can tell you that as a person who works, people who are looking for work, all these water on-farm conservation creates jobs right now. And I'm glad with this increased revenue, you have the money to pay the Imperial County for its mesquite plan. That issue has been solved as far as I'm concerned. from earlier today. You remember our conversation, because you have not earmarked where this increased revenue is going for. I have not seen that type of earmarks. I'd like to ask that question. Will that be presented to us as a line item? How much water net gain or loss you're receiving from the water transfer now that you have an increased revenue, and how you're going to use that revenue? Thank you very much.
Thank you. Thank you, Mr. Reyes. Claire Collins.
Hi there. My name's Claire Collins. I'm an environmental attorney. I'm part of the firm that challenged the QSA, and we won on the basis that it was unconstitutional. So you guys probably aren't really thrilled to see me, but I'm not here in that capacity tonight. I'm actually here representing an environmental group called CURE, Citizens United for Resources and the Environment. And we actually also have a handout. I'm not sure what the protocol is for this, but can I hand this over? Okay. Thanks. Mr. Brady, in his presentation to the congressional hearing, repeatedly referenced basically 3 sets of documents, which Craig Morgan also mentioned. Order 8412 from September 1984, Water Rights Order 8820 from September 1988, and Water Rights Decision 1600 from June 1984. These are the basis for where we are today with the QSA. They're the origin, as Ms. Shields spoke about, and Mr. Brady, about the 25-year process of collaboration. That 25-year process, however, although it seems long and important, is also an indicator of how far removed we are now from where this all started. And since some people have been giving me a little bit of history today, I hope you will indulge me just for a moment. I think it's actually kind of ironic that Mr. Jordan, who's the grandchild of the Elmore family, that we've got Elmores that started this whole thing. If you look at this from 84, because there was flooding. Too much water was going into the Salton Sea, and it was flooding his land. And that was considered a non-reasonable use. And that was the basis for this. Well, ironically, 25 years later, shockingly, some things in the valley have changed. And the new problem, there's not enough water in the Salton Sea. And to some extent, tonight I'm here on behalf of the Salton Sea. Since the QSA was signed in 2003, the sea has lost 6 feet in elevation, which exposed 8 square miles of playa, and the playa is death. At the very back of this packet, there's a series of maps. These maps were prepared actually by the Air Pollution Control District, so I don't take credit for them, although hopefully Aileen Tabor, who's here tonight, who did prepare them, may get up and explain them a little bit to you. But if you go through the back, you'll see the relative elevations of the sea over time. And the increasing white area at the end is going to show you how much is going to be exposed eventually as a result of the decrease of flows to the Salton Sea. Interestingly, your attorney, David Osias, at the trial said there's no birds in the Salton Sea, so kind of why do we care about them? And I came in here tonight and I laughed out loud when I saw right next to your board agendas the Salton Sea International Bird Festival. So apparently there are still some birds there. And what this says to me is that maybe your council doesn't know Imperial. And the more and more I see, the more and more I think, I'm not sure that he really speaks for you. Imperial's water rights are its greatest natural resource. And by Imperial, I mean Imperial County and Imperial Irrigation District, because you guys manage this. But since these times have changed, since we're not worried about flooding anymore, we're not worried about unreasonable uses, I submit to you that prevention of airborne dust and particles, that prevention of a rapid increase in asthma, in massive air pollution itself is a reasonable and beneficial use of this water. I submit to you that maintaining a beautiful resource with wildlife is a reasonable use of water. And I think that any federal or state agency would be hard-pressed to argue otherwise in a court of law and win. If you return to the pre-QSA conditions, it's going to be more jobs for this valley. It's going to be less air pollution, and it's going to mean less litigation. At this point, again, going back historically, The MWD had a great opportunity when Mr. Elmore said, "Quit flooding my land." MWD was fifth in line on the priorities on the Colorado River. It couldn't get its full allocation as soon as Arizona and Nevada started taking their allocations off the river in their full amounts. And MWD was pissed. MWD wanted its full 1.1. So what did they do? In my opinion, they blackmailed you into going forward on the QSA. They blackmailed you, and now San Diego's bribing you with $50 million. And I say that's not enough, because that's not the value of the future of Imperial Valley. The future of Imperial Valley is worth a whole lot more. The only fix for the Salton Sea and for the air is stopping the transfers. I don't understand, after reading, well, I didn't read all 330 CDs, Mr. Garber, that were in the trial, but I've read a lot of the material, and I still don't understand why. Why would you do this? What is the benefit to Imperial? So that's my question that I hope will be answered in the record. What ultimately is the benefit? The good news here is that this is a do-over. You guys have a chance to make things right. Most people don't get second chances. This is amazing. This is a door opener. Or some people say when God closes a door, sometimes he opens a window, and this is it. So with that, my question, well, I'm sorry, I am not going to leave it with that. One more thing. If you're going to get another legal opinion, get an independent one. SOMAC's not independent. Thank you.
Thank you. Luis Olmedo.
Luis Olmedo. Good evening. I'm glad I went after her because she pretty much read my mind, a lot of these things. But the QSA seems more and more as I won't say that again. But, oh, what the heck. It seems more an under the table deal. And the reason why is because it seems like only a small number of individuals seem to benefit from this deal. And those that are that have the largest benefit from this transfer need to be liable for the environmental impacts. If the QSA does not assure a good environmental mitigation, the farming industry will be the ones to pay for the burden. The EPA has recently made some decisions, and who knows what the forecast will be, but it seems to be putting quite a toll on the farming industry as it is now. Just airborne PM10, and just recently, 3 months ago, another study on asthma that, and you might say, well, it could be a small number, but this was over 3,000, nearly 4,000 students in Imperial County that were surveyed, and a study was conducted that demonstrated we have 3 times more asthma than anywhere in the state. Judge Candy indicated in the language, it says, when he used the magic language, and I'd really like to see if the magic language is going to be cleared to make a stronger commitment to funding for mitigation of the Salton Sea and for any other possible sources of mitigation that may be required to address all environmental impacts from this transfer. And as you move with other possible workshops and just explaining the background on the QSA, I think it's also important that these questions also be addressed. And one of this is IID a public resource? The IID belongs to who? Does the Energy Department subsidize the Water Department? If the QSA was to make IID more efficient, who are the beneficiaries? And what is IID's present perfected water rights? And, last question is, who's paying for legal fees for QSA? Water Department? And if so, is it only the Water Department? So I think those were also important questions that should be answered as you address the background on the QSA. Thank you.
Thank you, Luis. Kimberly Juanfu. sorry.
Hello, good evening. My name is Kimberly Huang Fu, and I recently was part of the legal team that resulted in invalidation of the quantification settlement agreement. However, I'm not here on behalf of the growers necessarily, but I'm here to speak on behalf of the Valley as a whole. What I've heard tonight is the general theme is the benefits of the QSA basically will result in, one, short-term funding through the various San Diego, let's say the $50 million comes through, and also, two, protection of the water rights. As my colleague Claire addressed, the Part 417 proceedings are no longer an issue today. That came from a historical overview stemming back to the 1980s. Today, there's recent growth in the valley. Water is needed for farming as well as an influx in sustainable and renewable energy sources. These are all products that could ultimately result in tax incentives and additional revenue for the valley. So what will be the Salton Sea fix? We've heard various misstatements. In court, your attorney, Mr. Osias, said that, but no one knows whether restoration of the sea will prove to be feasible. 15 years will allow the state, the Salton Sea Authority, and the governor's office time to study and implement identified feasible restoration measures. Well, I'm sorry, folks, but we don't have 15 years. The sea has progressively rescinded. There is an increase in the amount of exposed shoreline, which therefore leads to an increase in PM10 levels. What does that mean for the people of Imperial? Well, that means increased asthma rates, and also the Salton Sea restoration itself will become possibly not infeasible because mitigation costs will be exorbitant and it will no longer be feasible to restore the sea. So what the IID board understood at the time that it approved the QSA was that there would be a Salton Sea fix. The state would come in and provide X amount, potentially in the $9 billion range, to restore the Salton Sea. What we heard at trial, however, in Sacramento is that that is not necessarily the case. So what is the true meaning behind the QSA and what was negotiated back in 2003? I have a letter from Mr. Lloyd Allen dated October 29th, 2003, in which he stated that as part of the QSA arrangement, the state has committed to undertake restoration of the Salton Sea. Except for the fixed amount dedicated by IID, San Diego, and Coachella, recently enacted state legislation provides that future state actions to restore the Salton Sea will be the sole responsibility of the state. Well, that is no longer the case, and so we need to come up with a viable solution for the Salton Sea. So this brings me back to my earlier point. We're concerned about 50 million here, 30 million there. This is short-term thinking. We need to focus on the long-term solution. The administrative record created by the IID back in 2003 shows that cost projections for mitigation alone would be $178 million. $178 million is greatly exceeds the $50 million that you could get from San Diego or from MWD. In addition to that, restoration, the preferred alternative, it now shows that it will be $9 billion. So I'm sorry, but $50 million is merely a drop in the bucket and will not resolve any long-term sustainable goals here. Okay, and my final point is there were several misstatements in the PowerPoint presentation. First, let's see. Okay, first it was provided that the court found that there was a meeting of the minds. Okay, that was not the case. The court expressly found that the IID board approved the QSA JPA on October 2nd. However, in this massive administrative record of 500,000 pages of documents, somehow magically a critical email was missing from the record. This was an email from the Department of Fish and Game Director, Mr. Height. He wrote an email on October 6th basically saying, thank you for sending me the draft QSA JPA. I am still in the process of reviewing it, and we will get back to you. However, we are not comfortable with the state signing a blank check. Okay, so on October 2nd, the board approved this magical final version of the QSA JPA, which I might note that draft copies of this agreement were not included in the record. So for council to say that that the court determined that there was a meeting of the minds is a gross misstatement. And that is all I have. Thank you so much.
Thank you, Kimberly. Matt Desert.
Yeah, hi, good evening, Matt Desert. I'm a resident of El Centro. First of all, I'd like to start off by recommending that you get some new attorneys to negotiate this QSA out, and why don't you try getting some female attorneys that are as smart and pretty as these two that have come before you tonight. None of us understand what's going on with our federal government or the state government. We don't understand. We can't see what they're doing regardless of who's in the administration. And I got to tell you, and I got to tell all the IID staff in the audience, that the residents and the ratepayers in Imperial County do not understand what's going on at the IID, in the water department, or the power department. We want to know where we're at today with the QSA. Well, what do we know today that we didn't know before? We know that the QSA has been invalidated. We also know that Director Kuhn is here tonight, and he would not have voted for the QSA had he known that the state's responsibility was not included. Now, those are two pretty significant things that we haven't been able to get out of the IID staff and administration in their presentations. They've been going in an opposite direction, that they're going to win this thing come hell or high water. So as we go forward, we talk about liability and the state liability. And the ladies tonight also told you about that state liability. Mr. Kuhn told you about that state liability. It's not there. And we know that. And who's going to take care of that C? The resolution that was passed for your guys to go forward on your stay and appeal process included working with the County of Imperial to negotiate, to come to terms on a common plan. And I ask you today, IID Board, IID Administration, have you contacted the County of Imperial? I don't think you have. Mr. Brady doesn't know. Have they? No, you shook your head. I thought maybe you were going to answer. And why not include the County of Imperial in a second opinion on choosing that legal staff? You've been told tonight by multiple people, by these lady attorneys that have made such a great presentation, that the attorney that you've chosen is tainted. He has a history, he has a past, and it's not a good choice. So start over, contact the County of Imperial, bring the two boards together that are responsible for our water, power, and our whole county, and come to some common agreement. I've got some specific questions to ask about money and finances. The $50 million, where is it supposed to go? Eric Reyes has asked, is it earmarked? The $50 million from San Diego that you're getting, where is it going? The transfer money that the county, that the IID has already received from the past transfers, that's supposed to go to conservation. How much is it? I heard a couple months ago or 6 months ago it was $78 million, but we haven't got a total. Also, is it still there, or has it been spent? Is it in a locked box sitting for the future to be used on those projects? Or perhaps it's not there, and that's why you're after this $50 million jump change from San Diego to move forward. Finally, how much money have we spent on the QSA attorneys, consultants, IID staff to get where we are today? That question's been asked before, to get an accounting about what we do with our legal expenses at the IID. If it all comes out of one account, or does it come out of different accounts in different departments? And it's a confusing question. It's a confusing answer. But in regards to the QSA, we need to understand where we're at and where we're going. We need to get new attorneys to negotiate this. We need to move forward. New attorneys will allow us to not to work with Mr. Morgan as much in the Imperial Group. We're all tired of them, aren't we? Thank you.
Thank you. Peter Osterkamp.
Peter Osterkamp, local farmer. First time doing this. A little nervous. I'd like to personally thank the Imperial County for its success in giving the IID the opportunity to reevaluate the QSA. My children, the Valley's children, will be better protected from the failure of the Salton Sea because of it. I want to know how you plan to prevent the air quality issues associated or similar to that to the Owens Valley, and how my children's children won't have to pay for it. My other question is, how is the QSA good for the people? You guys talk about how it's always good for the district. I want to know how it's good for the people. And I guess the last question I have is, on the second opinion, I've been told that SOMAC actually works for the state of Arizona on the Colorado River issues. So that's another question I had for you guys. Thank you.
Thank you. Ronald Limegruber.
Thank you, Mr. President. We've had a great presentation by the ID staff, and they've talked about all the benefits. I'd like to mention a few of the things that I don't think are benefits. We talk about this great $50 million chump change bribe that we got out of San Diego and the renegotiating. But I want to mention, originally when Bruce Kuhn voted in favor for this, he said, I think one of the reasons is because their third-party impacts will be mitigated. San Diego is going to pay for all third-party impacts. And I believe the number when Mr. Carter was talking about it was $130 million of mitigation money that San Diego will pay for third-party impact for social mitigation problems. And I think that was 130 million. I think our dream team, our legal staff, negotiated that down to 40 million from San Diego and 10 million from ID. So down from 130 million down to 40 million from San Diego. When I do the simple math, that's about a 67% decrease. That's about $70 million. But we got a $50 million upfront check because we renegotiated the price. The numbers don't match up. One other question I've got for our ID staff and our water expert, Mr. Dr. Eckhart, is we were told that the Coachella water was system water, and that part of the Coachella water was transferred at $75 an acre foot, and I think part was at the $110 an acre foot. And that was going to be system water. That's what it was going to cost to conserve water, so we could get that off the system. So it wasn't going to be a drain on the IED. It wasn't going to be a drain on the ag community, because we had that low-hanging fruit, that water that we could conserve for that to transfer Coachella. Now, fast forward that to some negotiation they were making with our fellow, I think it was Hudson Ranch 2. And I think in a study they've come out, I think the average price of water that our local industry is going to pay is $485 an acre foot for water. I could be off on my numbers a little bit. But so now, and that was done because that's going to be conserved water that we're going to have to go beyond and above. So we're going to transfer water to Coachella so they can irrigate their golf courses at 75 to 110. But our own industry, we're going to sell it to them at 485 because that's conserved water. That's the new conserved water rate. It doesn't make sense. It doesn't benefit the valley. And you say this, Dr. Brady said this QSA is good for the valley. The Salton Sea is better off with a QSA than without it. I think, Stella, you were way ahead in the deal when you voted no on this. I believe the comments to the paper were, I don't trust the state. And I personally still don't trust the state. The Judge Candide doesn't trust the state. But we still are being represented by our dream team that the state's somehow on the hook for this. How many hammers have to hit you on the head when we have I wish I could take credit for this comment, but it wasn't from me. It was on Melissa McKee, another outstanding attorney at the case. She said, IID presented this 500,000-page document record, and the trial was based on these documents. But somehow, this Height email wasn't in that document record. She said she felt like this would have been like going to the Nuremberg trials with 1932 information. You guys have a great opportunity. You have more information than the past board had. You get to a redo. You get another look. Don't make the same mistakes that the last board made. And Bruce Kuhn made a mistake. The state honwoggled him. They told him something that wasn't true. Stella was smarter than that. She said she didn't trust the state, and she was right. And John Pierre, you said you didn't like the QSA. That was your platform. It wasn't good for the Valley. So tell me what has changed in the QSA that makes it good for the Valley today, but in 2003, it was bad for the Valley. There's got to be something in there. I'm still looking for it. One last comment I'd like to make is, I think I've said this before. You guys are tired of the legal fees, and we're definitely tired of the legal fees. The way you get the public to buy into this is public input. You've got to get perceived public participation for the public to buy into this. And when you hire an attorney that works for Arizona, that has already worked for you before and gives you answers, that's not a perceived public bias. You're not getting a benefit for the public. You're getting an answer that you guys want to have. Get a non-biased opinion so we can all be better informed in this. Thank you very much.
Ralph Menville.
Good evening. First of all, I'd like to thank you for having the workshop. I know I asked for it the last time I was here, and I also asked that you would also try to get a second opinion. I want to thank you for going down that trail. I'll be quick because there's a lot of people here. Tonight you showed us the good, as you might say, and I know that that the general manager said, hopefully I'm quoting it correctly, but it was that the QSA was not perfect, but it protected the IID water rights. And so my question is what is not perfect and what is bad about the QSA? And I would like to see a second workshop that we talk about what is not perfect and what, let us see what it is so that we know, so we can decide. And also I'd like to say that when I was an IID board member that I did have Stuart Somack did come and speak to us, and he did some things, and I would vote no on Stuart Somack. And I'd also like to say, Mr. President, do not forget what I told you at the last meeting, that the judge gave you a gift. Use it wisely. Thank you.
Oscar Gonzalez.
My name's Oscar Gonzalez, and I'm representing tonight a new organization called Jesus Emmanuel Immaculate Educational Foundation, and it's an organization designed to help disenfranchised with educational, social, and economical, political needs in Imperial Valley. And I'm a consultant to that group. My son, Jesus Roybal, who is housed in Phoenix, and some of his relatives. The organization is basically out of Albuquerque, New Mexico, but they plan to open an office here in El Centro shortly. I'm very happy to be here tonight. I'm speaking on behalf of the QSA, and I support Estela Mendoza because I think she had foresight, and I want to admit that I made a terrible mistake because I was for the water transfer, had incorrect information, but I found out that most of the people, vast of the majority of the people that were backing Estela, including my compadre, and many people, Hildy Carrillo, Victor, and many people in Calexico, couldn't tell you specifically why they were against it. They just said, oh, I'm for it, I'm against it. And I really couldn't tell you why I was for it either. And I'm not so sure that I can tell you right now why I'm really supporting the QSA, but I want you to do the right thing for the right reasons. And I really dislike that Mr. Desert for criticizing Mr. Garber. I think we're not here to degrade anybody. I think Mr. Garber went to law school. He's a competent attorney, respectful. He's got a family. I think the man is intelligent. He's a lawyer. I think the guy may or may not be the best attorney. No, I didn't mean it that way, Mr. Garber.
God, I'm glad he's talking about you.
But he might need help. We got Mr. John Penn Carter, an excellent guy who was here when the water transfer. Hire him and his staff. He's an excellent attorney, as well as Mr. Carter. But let me just say that I think my father is happy right now because I'm here tonight. I'm first generation of the Gonzalez and also Hernandez. My mother was Hernandez, and who graduated from college in 1970. My grandfather came here in 1916. All of his life he worked out in the field and worked for Brock. My dad worked for Brock too at age 11, and at age 32 he was I think a foreman for Brock, and eventually Brock helped him get a job at Plaster City. And eventually, my dad wanted me to work in Plaster City. And thanks to Orbia Hanks, when he introduced the flag program in Calexico, my dad didn't want me to play football. But thanks to Orbia Hanks in the late 50s, he introduced a beautiful program, boxing. I was no good at boxing. I got knocked out. But I was a very good football player. I made All Valley, and I was no good at academics, really, but I went on a football scholarship out of Allen Hancock, and I played at UCSB, and I was a good punter. I punted 38.7, but I almost flunked out of UCSB the first 2 years, but the last 2 years I was an academic scholar, 3.75, and I went to Cal State Northridge and graduated with 3.752 in 1 year. I graduated with a public administration in public policy, and also budget. I hope that your board, as I was telling, and I was out of order earlier, put a simple budget where it says debits and credits, because I don't understand the IID budget. And you told me to talk to Mr. Brady. I've been reading your budget for 15
Blow his phone
years.
up. Call him. He doesn't answer.
I don't understand it. I've been coming to these meetings for 15 years, and for the love of Pete and the love of Chula, I don't understand the budget. You know, I don't know if you guys are trying deliberately or subtly hiding, but I don't understand the budget, honest. And I know how to read budgets because I was a senior analyst. I was the first affirmative action officer at age 22 for the County of Imperial, and I had 19 departments under me, and I used to monitor them, and I could read a budget. So it isn't because I don't know how to read a budget. I know how to read a budget. So,
Oscar, what we could do is, can you give him a budget?
Yeah, I certainly will.
You can
yes,
come,
Mr. Gonzalez.
and then come back to the meeting and ask.
I'd like to sit down with whoever's the financial officer. And
that would be Mr. Brokey.
Okay.
That would
All right,
be
Oscar.
Mr. Brokey, that's him. Go talk to him.
Honest to God, I've been here 15 years involved and so forth. And let me just say one thing. I remember when Don Cox, may he rest in peace, Calexico people hated farmers, you know. And Marlene Thomas said, Oscar, you know, I want you to help Don Cox. I didn't know who Don Cox was. And she said, he's running for the IID. And then I told Louis, you know what? This guy's running for IID. And he said, I don't want no farmers. We hate farmers. I said, Louis, he's going to pay a lot of money, and I'm going to give you all the money for you. Okay, bring him over.
All right, Oscar.
So anyway, he won. But to make a long story short, I support the QSA. And I want to tell you one thing. Every time I've been helping farmers, I've never lost an election in Calexico and El Centro. Every campaign that I've managed in Calexico and El Centro, I've never lost one.
Thank you, Oscar.
You bet.
Now we'll move on to, I think we are done. He was the last one.
Yeah.
We'll move on to director comments.
Okay. I would just like to thank you all for coming and for talking to us. We appreciate you coming here, and I can tell you that we all listened to you with an open mind. I know I did.
Director Buddy.
Thank you. Again, I'd like to thank the public and the staff for their presentation and the public for their questions. I'm looking forward to having those answered and discussing those answers. I've always believed in operating and negotiating from a place of strength. And maybe that place is where the difference of opinion is, where's that place at? But it should be face-to-face, eye-to-eye. Never yield an upper hand, somebody else's upper hand, even if it's a bully pulpit. I agree. There's one question I agree with, or a suggestion that I agree the public with. It's something they need and that I need. So I'm going to ask the president to please get us an independent legal opinion. Thank you.
Director Menville.
Yes, first of all, I want to thank everybody coming for the workshop and appreciate the comments, and I'll just say what I have said before, that when we try to work the QSA out, I'm not for giving up any more water, I'm not putting up any more money, and I'm not taking on any more liability, and we're going to definitely ask what we bargained for in the first place. Thank you.
Director Hanks.
I just, first, I think this public hearing, first of several, I hope. I think the comments that were made out there helps this board as we move forward, because we hear all types of comments, all different directions. But the message was pretty clear. You don't necessarily have to blow it up, and you don't necessarily have to push the restart button either. We have heard, as mentioned by several people, that it's not perfect. I think that's a fair statement. I think we have to identify those areas and move forward with them. We also, I'm very interested in a second opinion. Although I have a lot of respect for Stu Solmach, based on what I heard here today, I have some question whether he's the right guy because of his association with a couple of prior issues and also with the state of Arizona. But I will pursue the issues that I see in the QSA that I think needs to have some attention. I plan on working close with the staff to identify these, so at least they are able to come forward. I've spent a lot of sleepless nights. I have a lot of notes, and I think there's some areas that are very important to this valley as far as getting it right. I think that's the whole issue. It has to be right, and the linchpin, as it's been called, the Salton Sea. And I heard former Director Bruce Kuhn loud and clear. I've heard other directors mention the same thing about the key to this whole thing is the Salton Sea. It's the albatross around our neck, and if it's not right, water can't leave this place. It would be the death knell for Imperial County. So I'm looking forward to moving forward on this, but I've also hoped that the staff heard, and don't get just set on the way in the same old, because that's not going to get it done. We have to get the Imperial County on the same page as we move forward if we're going to get it straightened out and have it done correctly. Some of the things that I'm very concerned with, earlier I had a chance to visit with Director Minville and point some of these things out, because I think they would be used in future negotiations. I'm not going to bring them forward right now, but I will be sharing them with the staff, and I think it's for me to support moving forward and putting this together. These issues have to be addressed, but it's definitely not pushing a restart button on everything.
Thank you, Director Hanks. Well, as everybody can see, is that we are moving forward with this situation at hand. I hope that you guys would give us time and be patient with us as we conduct our future workshops and our meetings to see how we proceed forward. And I think this was our first step. This is our first step. I think we share a lot of the same concerns. I've heard different things, and there's some questions that if I'd be happy to give you my card and email me certain reasons, since obviously I wasn't on the board at the time of 2003, and one of them is why would anybody think, the QSA was invalidated because the state couldn't issue a blank check to mitigate the C. So why would I hear a lot of comments tonight that that the district didn't take care of mitigation of the Salton Sea? So if you could email me as to how those two differ, or the QSA contract didn't take care of that particular issue, that would be great for my information. And as well as there's a bunch of other things that we can get into, but obviously we're not answering questions. But for the last 3 years, I've heard that we've allowed our attorneys to negotiate for us a lot, and I see a lot of people in here who constantly have come up to the podium and have said that. As one director, I didn't agree to a second opinion to take us into the future as far as negotiate or anything of that sort. My second opinion is what Jeff was said earlier on the court cases, such as the IID had the right to enter into the agreement, and all those different trial court proceedings. So I'm not sure what exactly everybody was thinking that the second opinion was going to entail, but it was basically, can the IID approve the QSA by majority vote? Not if all these things that were said by Jeff Garber, are they true or not? But as far as someone to give me one director a second opinion as to how I should proceed, I'm not looking for that. I think the 5 board directors are here listening to the people, and I think that's what the people wanted. Now, if people think otherwise, well, obviously that's a flip-flop. So with that, I thank you all for coming tonight, and I look forward to continuing the workshops. Thank you.